So now we are here on article number 20 discussion, which is under the heading of right to freedom. Please do check all the earlier videos so that it helps you get a connect. Now when we try to study article 20, we'll first see what the constitution says about it, and then we'll go on for the detailed discussion as we do in the other context. Now the article number 20, you can see there are three clauses, sub-clauses basically about it. Now firstly, what is a broader idea which is given in article 20? It is about freedom only, but what is a broader idea? The broader idea is protection in respect of conviction for offenses. तो कोई भी जो ऑफेंस हुआ है उसके लिए आपको कन्विक्ट कब कब माना जाएगा, कब कब नहीं माना जाएगा, उस केस में what are the protections? It is another form of freedom only. So how you're getting them? So three forms they have talked about, and in all these three forms, one thing you will notice is that they have talked about no person. So one takeaway that you will have from article 20 is that it is applicable to all persons and not only citizens, right? That is one idea. Now let's see कुछ writings देखते हैं, then we'll go back to that provision. Firstly, it says that in this you're getting the protection against arbitrary and excessive punishment to an accused person. So किसी भी person जो accused है किसी particular offense के लिए, उसको arbitrary punishment नहीं मिलना चाहिए, haphazard random punishment the person should not get, and excessive punishment the person should not get, which means जितनी crime की गई है उतना ही punishment मिलना चाहिए, ठीक है, and that too it should be within the ambit of the law and should not be arbitrary. So basically यहाँ पे तीन broader provisions, जैसा हमने देखा, three broader provisions are talked about. Now each of these three broader provisions are also known by some other phrases जो आपके बुक में दिया हुआ है, but it is not given in the constitution. For example, for the first clause, you have a term like ex post facto. Second के लिए you have a term like double jeopardy, and third के लिए you have a term like self incrimination. But none of these you will find is given here. So here they have explained you the meaning, but then those terms are also important. Now before we get on to this, understand something very broadly what I'm trying to tell you. See, when a law is made, there are two types of laws which are made, okay? Now see, whenever any law is made, the law made can be of two types. One can be the retrospective law. Another could be the prospective law. Usually, majority of the laws which are made by the legislature are in this category, prospective. What does prospective means? Prospective laws means it will affect all those acts which are done after the law comes into effect. So let's say the law comes into effect on X date. Let's say today or whatever date. So it will be applicable for all the acts done after that. Okay, acts done after. So the applicability of the prospective. So on prospective, जैसे कहते हैं ना prospective future, prospective partner. So something looking for the future. So whatever acts would be done after this, it would be applicable for that. And majority of the laws, as I just said, are falling in this category. But there are certain laws which can be made by the legislature which covers those actions also which are already done. So covers the actions already done. So for example, in this case, what will happen? Let's say even if the law gets implemented on this date, or let's say it comes into effect on this date, they can tell you that it will be applicable for all the activities done before that also. ठीक है, ये भी possibility संभव है. This could also be done. And the parliament is not, as such, the legislature is not restricted by anything that they only have to make prospective. They can make retrospective and prospective also. So retrospective law is not illegal. मतलब ये हो रहा है अगर, तो this is not wrong as such. Illegal नहीं है, this is allowed. So here the past actions also get affected, even if the law would have, let's say, been passed somewhere later in the future. But to prevent this from affecting the convicts, we have the article. So please be very careful with the idea that this is not something which is illegal. This is very, very much legal. They have the ambit. The legislature in originality can go for either of the law. But under Article 20, Clause 1, as you can see here, under Article 20, Clause 1, what is the idea? That it protects you from this kind of a law. कि आप past में जाके उसको impact नहीं करवा सकते हो. ठीक है, this is the broader idea. Now we'll try to see what is given in the constitution. So it says that no person shall be convicted of any offense except for violation of a law in force at the time of commission of the act charged as an offense. So you cannot convict any person of any offense if the person has committed that offense somewhere in past. So आप सिर्फ तभी उसको punish कर सकते हो when the person has violated the law which was in force at the time of commission of the act. So when the person has acted at that point of time, whatever law was in force, only according to it the person can be convicted, not going by the past thing, nor subjected to penalty greater than which might have been inflicted under the law in force at the time of commission of the offense. So also, if the person has done something X act at X date on X date, उस समय जो law applicable है, only that will be valid here, and according to that valid law, whatever punishment is to be given, only that should be given. इस punishment को हम past के according increase nahi karenge. So that penalty should not be greater than what has been done earlier. Okay, so this is the broader idea. Now when we try to see again the details of it, so what we understand is that this protection from this past thing is called as ex post facto legislation, which means you are prohibiting the retrospective legislation. ठीक है, जो पुराने समय से लागू है उसको आप रोकते हो. So यहाँ पे क्या होता है, this prohibit the retrospective imposition of the penalty, that you will not be penalized for something that you have done in the past if that law did not exist then. So if a law exists now but it was not in force when you committed that act, you will not be punished for that act. This is the simple explanation. But what you have to remember, firstly, that okay, no person shall be convicted of any offense except for violation of law, जो अभी आपको बताया, and same goes for penalty. This is what is written in the constitution. But you have to remember that this freedom you get or this limitation you get is imposed only on the criminal laws and not on the civil or the tax laws. Which means let's say अगर टैक्सेशन का है तो आपने पुराने समय का भी जो टैक्स नहीं दिया वो आपको पे तो करना ही पड़ता है ना. सो सिविल लॉज हो गए या फिर टैक्स लॉज हो गए, दे कैन बी अप्लाइड रेट्रोस्पेक्टिवली. रेट्रोस्पेक्टिवली मीन्स गोइंग बैक इन द पास्ट एंड अप्लाइंग इट फ्रॉम द पास्ट. बट criminal for the criminal laws, if you have committed any crime in the past and any law for that crime did not exist then you will not be penalized as per that law. Okay, another thing that you have to remember, that it prohibits only the conviction of sentence under जैसा बोला हमने कि criminal law, but also you have to remember कि so law जो है उसके अंडर में ही कन्विक्शन से आपको बचाएगा. किसी ट्रायल से अगर आपका प्रोसेस हियरिंग वगैरह चल रहा है, सो दैट इज़ नॉट गोइंग टू बी सेव्ड, लाइक यू आर नॉट गोइंग टू बी सेव्ड फ्रॉम द ट्रायल. एंड ऑल्सो इफ़ यू गेट दिस इम्यूनिटी अंडर दिस पर्टिकुलर आर्टिकल, this cannot be claimed in case of preventive detention. Now we have a whole article to be discussed on the preventive detention. उसको हम अगले टॉपिक में करेंगे as a separate, but अभी के लिए you just remember that preventive detention means detaining somebody or taking somebody in custody as prevention. That you have an maybe some intelligence agency has given you the idea or something like that this person might be or maybe from the past record of the person, that the person might be a threat in the immediate time. So you detain that person ताकि उसके वजह से किसी भी तरीके का threat ना हो. ठीक है, कोई chaos ना हो, violence ना हो. So as a prevention or as a preventive measure you are detaining that person. ठीक है, तो इस केस में this is not allowed. So this is a broader idea about जो आपको ध्यान रखना है about this particular provision or the article, which is also known as, in other words, ex post facto law, which is retrospectively imposition of the penalties. Another thing which is given in the Constitution, clause 2, is no person shall be prosecuted and punished for the same offense more than once. So remember, if you are committing any offense more than once, you will not be punished for it again and again. So if the offense is same, then the prosecution and punishment will just happen once. Okay? Now here there might be certain questions in your mind which I'll try to answer in the coming few minutes. But firstly, इसके लिए जो एक अलग से term use होता है, that is called as double jeopardy, which means double punishment एक ही चीज़ के लिए नहीं मिलनी है. However, as such, this phrase is not used in the Constitution. As you can see, this is nowhere written double jeopardy. They have given the detailed explanation, but the technical term used for this is डबल jeopardy. तो अब यहाँ पर क्या है कि फर्स्टली यू हैव टू रिमेंबर दैट दिस इज एप्लीकेबल इन द केस ऑफ the proceedings which are judicial in nature, so which is happening either in front of a court of law or in front of a judicial tribunal. This will not be applicable, let's say, before any departmental or administrative authority. So let's say there has been some action by you. Let's say there is a government servant and who was punished for an offense in a court. Now for the same offense, if the person is also punished in the administration or in his or her own department, that would be allowed. ठीक है, ये आपको ध्यान रखना है. That would be allowed because at the same place this cannot happen. That in the court only, if twice you are being punished for the same thing, that will not be allowed. But अगर department में कुछ भी हो रहा है, the court has no, like no relation with that thing. So that could be done. Also, another thing that you have to remember that in the subsequent proceedings, like एक proceeding में for the same offense अगर आपके लिए कोई punishment दे दिया गया है, so in the subsequent proceeding you will not be punished again and again. But let's say if you have done some other kind of a crime, definitely you will get the punishment for that. ठीक है, तो ये सिर्फ आपको ध्यान रखना है कि वो सिर्फ उस पर्टिकुलर प्रोविजन के लिए अलाउड होगा जिसके लिए आपको चार्ज किया जा रहा है. फॉर एग्जाम्पल, लेट्स से देयर इज एनी एक्ट, उसके मल्टीपल प्रोविजंस हैं. So for one provision, if you have, like, let's say you have done 2 crimes and one falls under one provision, another falls under another provision. So for that one provision, you will get punishment once only. But if your crime is falling under the second provision, then also you will be punished because it is 2 separate provision of, even if it's the same act. Okay? So if there are offenses under 2 different sections, they will be distinct from each other. Then that does not count to be double jeopardy. It counts only for the same thing. I hope now you have got that point. Next, third यहाँ पे क्या है? No person accused of any offense shall be compelled to be a witness against himself. Now focus on again the words, and no specific phrase you are seeing here, but the phrase used for this is no self-incrimination, which means that no person who is accused of any offense is going to be forced or compelled that you have to be witness against your own self. Then you will say कि कुछ तो चीज़ें होती हैं जैसे मेडिकल टेस्ट वगैरह करते हैं, ब्लड सैम्पल्स कलेक्ट करना और वो सब, तो उस पर भी हम बात करेंगे. ठीक है, फर्स्टली यू हैव टू रिमेंबर दैट ये जो इम्यूनिटी है, this is only about the oral and the documentary evidence. Oral is like verbally you are telling, and any kind of documentation if you are providing. So in that case जो है, क्योंकि ये सब क्या है, nature of communication, you're trying to communicate with the help of these evidences. So in that case you will not be forced कि आपको अपने against witness बनना है. लेकिन this is not applicable to, or this does not extend to compulsory production of the material objects, which means that any kind of, let's say, property or something like that, any possession is there with with the person who is accused. In that case that would be allowed. Also, if there is a compulsion to give thumb impression, specimen signature, blood specimens, or any kind of medical examinations, that is also allowed. In that case ये वाला applicable नहीं होगा. Also, compulsory exhibition of the body, if your body needs to be checked for that matter, that would also be allowed. Okay, so again here also this is applicable only for the criminal proceedings, like here it was applicable only for the criminal laws, so not for the civil and the any kind of other non-criminal nature. ठीक है, so ये आपको चीज़ें याद रखनी है. Also ये वाला तो हमने कर ही लिया था. फाहिमा शीरीन वर्सेस स्टेट ऑफ केरला, हाई कोर्ट ने जो राइट टू इंटरनेट एक्सेस को एज अ फंडामेंटल राइट बनाया. आई होप यू रिमेंबर, लास्ट क्लास में हमने इस पे बात करी हुई थी. और 21 में ये प्राइवेसी से कैसे रिलेटेड है, इस पर जब हम प्राइवेसी पे बात करेंगे 21 पे बात करेंगे, सो विल टॉक अबाउट इट. ठीक है, सो दिस इज जस्ट अ करंट अफेयर्स एडिशन टू दैट. बट हियर यू हैव टू रिमेंबर कि किसी भी तरीके के इस तरीके की जो प्रोसीडिंग्स हो रही हैं उसमें एक्सेप्ट these things which are very categorically presented, that okay, these are the exceptions. Apart from that, you will not be forced, or the accused will not be forced or compelled to act as a witness against himself. See, in prelims they can give you, let's say, the explanation and ask you to match. So you have to remember, what does self incrimination means? what does double jeopardy means, what does ex post facto law means. And none of these phrases are mentioned in the constitution. It is only the detailed explanation which is given in the constitution. Phrases आपको आपके understanding के लिए book से समझाए गए हैं. ठीक है, I hope you have got this idea. I hope you have also got this idea of the retrospective and the prospective laws. I'll see you again in the next video. Take care till then. Bye bye.